A little bit of my background does make sense oftentimes that I do have a military background. I also was a minister for about 20 years. So that kind of flavors the way I come at things. It's not always about a person's religion, but everything has to do with our religious faith or philosophical background. And I try to be aware of those and sensitive to yours as well. I have been head of the Kentucky Bar, served at every post that you could possibly do, educate other lawyers, and in fact, will be with some of those educational events this week. And I'm very well connected. The only purpose to say there is if you're not in Kentucky and you need referral, I can connect you with people who have solid credentials in other states. So now that sounds like I'm being very braggadocious. I'm not. I'll tell you anytime, even yesterday at a presentation I was doing, there's a lot of talented, smart, dedicated, hardworking people on the team here. So you are going to be interacting probably even more with them than you would me if you came into the firm. So you'll also see on that slide some of our practice areas. We're talking about estate planning, but we do everything from probate, veterans benefits, Medicaid benefits, guardianship, all of that's very intricately connected when you're doing elder law. So those are the things that I know a little bit about. I know very little about other stuff, bankruptcy or divorce, things along those lines. So with that said, let's get to it. Now, what could possibly go wrong? Here's sort of a roadmap of where we're going tonight. Leaving money to your children can create all kinds of problems. Now, I tend to be talking to people in their 70s, 80s, and 90s, leaving money for adult children. But estate planning is also going to be people with young children, young parents, perhaps with underage children. So we need to think about what that means establishing a guardian. You could have problems when you're talking about estate planning with marriage, divorce, remarriage. Even if I'm a single person or a married person, never been divorced or remarried, if I pass away, money going to an underage child is going to have to be governed by somebody. That's going to be my ex-spouse if I'm divorced or my present spouse, but that person could remarry. And so now I've got some guy with my wife influencing her on how she might spend money. I'll talk about opting against a will in just a little bit. But there's a lot of things that can come up, a lot of problems that can emerge in that way. We don't often think about bankruptcy or divorce, but if I leave money to my adult children, there are all sorts of midlife and later life issues that come up. How many mid-career people do you know that got laid off for a while and that created all kinds of financial struggles? And if bankruptcy was part of the solution they had to go through, leaving them an inheritance is going to be gobbled up by that bankruptcy. And we'll talk about that. So this is sort of where we're going. The last bullet point I want to call your attention to, in case you get bored and want to leave early, the capital gains and homestead exemptions. I'll talk about those in relationship to trusts and how and why you would use a trust in estate planning. But I see the biggest mistake made here where people have been encouraged, sometimes by well-meaning people, sometimes by attorneys who also mean well, but they don't specialize enough in estate planning to not avoid this error. You should never place your home in the name of your children. Never, ever. And yet that is the news, the encouragement you often get. The reason why is if you transfer your home into your children's name during your lifetime, you have given away your capital gains exclusion. So that $250,000 exclusion would now become a taxable gain. And at 20% on $250,000, you're talking about up to $50,000 in taxation that would hit unnecessarily. If they simply inherit it, then you're going to preserve that. Same thing with homestead exemptions. Your property tax now goes up if you're beyond age 65, just because you place that property in your children's name. Usually people do that because they're trying to avoid some conflict with Medicaid. There are so many better ways to do that in Medicaid planning rather than putting it in your children's names. So let's start pulling these apart one at a time. If you have children that are under age 18, a child cannot inherit money or real property. So you can either in your will or place your property in a trust, and the trust conditions would also say, look, we need some other trustee to be managing this asset, whether it's cash or real estate, for the underage children. Now, if you're putting that in either a will or a trust, I also encourage you to think about a separation of custodial care of a minor child and care of the finances. I have three children. If you have multiple children, it's always shocking to me how different our children can be, one personality to the next, right? So one of our children may be very well suited to give care, but one of our children may not be that good with finances. So if you're talking about choosing someone to be guardian over your minor children, let's say I would turn to my brother, maybe I could turn to my mother or my father, something like that. I'm going to have the same concerns. Great with children, maybe not so good with money. Another consideration along the same lines is maybe I think my parents would be great for my children, especially felt that way when I was younger in my 20s and 30s. But as I got older and my wife, still in her late 40s, had minor children living at home, I would not have wanted her parents in their 70s to be the custodian of a teenager. Teenagers are very busy. Maybe they're on traveling sports leagues, all kinds of school events. They need to go away and visit colleges. You want to think about somebody whose lifestyle is going to support what your children's needs are in those later teen years. You could choose a guardian that sort of ages out when they're minors. You might want, or very young children rather, elementary age, to be with one age group, and then perhaps do a different or shared arrangement later on. But in either case, separating the money from the custodial care could be a very, very wise, important decision to make. Now, similarly, what if one of your children is a special needs person with a special disability of some sort that needs additional care? And this can apply to us regardless of our age. I may have, in my 50s, I may have a 30-year-old child that still needs some sort of assistance from me. If they are left money and they are receiving governmental benefits, their inheritance is going to knock them off of their disability. Life insurances, even if it's not money that I hold outright, but I'm wanting to prepare for their future, you need to place in your will and or in your trust special needs provisions that say anything that goes to this child with the need has to receive that in a special needs trust. Now, if you do that, they get to receive every bit of that inheritance and they get to keep their governmental benefit as well. Now, typically that's going to be SSI, for instance, Social Security Insurance or Supplemental Security Insurance, rather. But it's not a whole lot of money. It's less than $1,000 a month. So the harm is not that big if you have a sizable estate to support them with. But oftentimes it's the Medicaid benefit, the healthcare coverage that is so essential to their life. So it doesn't matter if you think, I got plenty of money, I don't care about governmental benefits. The healthcare side, you're probably going to want to at least double think on. It might not be the end all of the argument, but something to be concerned about there. So special needs provisions in either case, in a will or a trust. Now, one other note of caution, if you don't put that in your will, it still can be created. A special needs trust could be created after you pass away. But if you fail to put it in your estate plan and draft it appropriately, and there's some key language, two trick phrases, if you will, that have to be in the will, that if you miss those, don't get them correct, then the type of special needs trust they can create is going to require a payback provision to the state of Kentucky. And that's a federal law, so it would apply across any state, not just Kentucky. So you having the foresight to put it in your trust or put it in your will means there's no payback to the government. And in their estate plan could pass it on to their children or back to their siblings or something like that. So these are very important provisions here. Now, let's move on to another one. Still thinking about underage folks, and I know maybe you have adult children, and we'll get there in just a moment. But if there are underage children, this still applies to those of us that have adult children because we could have my biological children pass away before I do, and the estate would go on to grandchildren who could be underage. So you still want to think about provisions like this. Underage children, they could go into the custody of not just their biological parent. That would be the first step of descent if they need someone to care for them custodially or financially. And so it's that biological parent. If I've divorced, now I've got my ex-wife controlling my money for my child since I've passed away. But what if their biological parent who survived me then passes away? It could be that my own child then is in the hands of this other parent that is no relationship to me, not even an ex-spouse. It was my ex-spouse's new spouse. So it can get very murky if you don't make specific provisions as to how this is going to be managed. Enough said about that. I think everybody gets the point. Let's move on to another one. Let's say I leave money to my children. I have three girls. All of them are in their 30s right now. If I were to die today and I leave money to them, what if they're going to go through a bankruptcy or a divorce themselves? And I've seen many professionals get mid-career, let's say in their 40s or 50s, have a car accident, develop a disability. I don't want money going directly to them in these situations. I want it to go to them in trust. You can put those provisions in your will. Now, I mentioned earlier special needs provisions, but what if they're not disabled in the sense of qualifying for governmental benefits? But I just don't want it to impact a workers' compensation claim or in the case of divorce or bankruptcy. Those kinds of provisions can be taken into account by the use of a power of appointment. A power of appointment is just that the executor of the estate would have the power to appoint someone else to receive that inheritance instead of the person that is going through the bankruptcy, going through the divorce, or whatever other difficult life circumstance. Let's say they're currently in treatment for addiction. The last thing I want to do to one of my children trying to go through rehab is give them $100,000 that they'll just be tempted to go spend on gambling or alcohol or drug use or whatever else like that. So that's where a power of appointment can work. The only problem here is what if that power of appointment is going to be exercised by the executor of your estate? If that executor is the one who is struggling with the addiction, then they're not going to override their own impulse, most likely. So you could make provisions within the will that if a person is going through these circumstances, they cannot be the executor and another person is, then they can exercise the power of appointment. So those are things, again, we don't often think about them, but it is something that very often does happen. These unfortunate situations are not a respecter of persons, and they do come at us all. Another thing to think about, I really do favor what I call staged distributions. So unless I am leaving money to my children and they're well into middle age, let's say in their 40s or 50s, I do not want to leave money to an 18 or a 20-year-old all in one lump sum. I want to roll it out in stages. And you'll notice here that I've listed 25, 30, and 35. There's a very specific reason for that. Again, you might say, well, my kids are beyond that. Yes, your kids might be, but your grandchildren probably aren't. And when we have someone getting ready to go to college and they fill out that federal form called a FAFSA, the federal aid form for student aid, the FAFSA is going to look at assets coming into their possession. So if you drop this money on them at age 20, it could knock them out of educational funding that they would have available to them, either lower interest or absolutely free grant money. I don't like that. I want to give them the money later on, age 25. Perhaps they're in graduate school, perhaps they're beyond whatever education they're going to do. And then I like giving it to them in three distributions, a little bit now, knowing they have a little bit more. That sort of incentivizes them to plan and use the money more frugally and I guess just more thoughtfully instead of all of it at once. And so they go and buy a new car. Now, the specific conditions can be added to any will or any trust. And you say, Scott, I don't much like giving it to them in distributions. And by the way, I'm just using three. You could use two, you could use five, you can use percentages and make it 40% at 25, and then the remainder 60 at age 30. But under when I start using specific conditions on how to give money to my children without causing them to go hog wild and spend it all at once, I can actually say, look, they can have 50% up front, but they cannot use it for anything but that or the other. So I could say a healthcare emergency, education, a home down payment, something like that. But they can't use it for a round the world trip across couch surfing across Europe. What you cannot do in specific conditions is you cannot say anything that is a legally protected option. So you can't say, as long as you belong to a particular religious faith or don't marry a particular ethnic group or something along those lines. If they have a protected right to do that thing, you can't limit those sorts of things. But you could also apply the specific condition, not just to the person receiving it, but to the thing that you're leaving. So let's say I'll leave the farm to the children, but they must maintain crops on the farm or only cut timber every 20 years. They can't develop it into, let's say, a housing complex or something like that. You can be very creative with the specific distributions that you want, how to stage them, how to limit them. Any number of things can be done here. You do want to think thoughtfully. Once you put a condition in place, you can't unwind it. You've already passed away, right? So creating some flexibility, perhaps you could leave some discretion in the hands of your executor, but you can be very creative here and accomplish a lot. Let's go to the other end of the spectrum. Let's say I live well into my 90s and I leave my children who are 20 years younger than me some money. So they're now at retirement age. They're either coming up on age 65 or maybe they're hitting age 72 and a half. One of the ways you can really create trouble here is let's say, I'm going to be silly for a second. Let's say I'm leaving somebody $1 million. Well, that sounds like a pretty good idea, but if they're coming at age 72 and they're going to have to start taking minimum distributions off of their IRA or their 401k, a lot of people are not aware that they hear all the great stuff about tax deferred 401ks, IRAs. It's not tax deferred forever. At age 72 and a half under current law, they used to be 70. In 2017, we moved it to 72 and a half. You start having to take distributions out of that on a schedule that will reduce or eliminate the entire investment by the time they reach their life expectancy. So given those sorts of, now their income has gone up at age 72 and a half, you distribute more money to them. And so instead of paying on that $1 million, the taxes that normally would be somewhere in the neighborhood of 20, 22%, you're going to push them all the way up to a 37%, at least under current law, a 37% tax. So you've gone through thousands upon thousands of extra dollars on taxes alone because we didn't think more cautiously about when to distribute and staging things out in a different kind of way. Now, this would get deep quick if I was going to go all the way down the rabbit hole. You have to sit down and talk with somebody and think through the different scenarios, but you more than likely, when we pass away, going to be giving to our heirs right about the very time where these sorts of things are happening. And a lot of family wealth would be wasted if we don't think more cautiously about it. So enter into a very careful estate plan. And that's going to mean in this case, this is going to have to involve a trust. And I know that's going to be, maybe 5 times more expensive than, let's just say, but it's pennies on the dollar compared to the tax loss that you're going to have otherwise. So something to really think about here. Side note, if you hear me present very often, I try to give a balanced perspective on 401 IRAs and even insurance policies. generally speaking, just to plant a little seed in your brain, I don't like any of these things going directly to the spouse. Normally, in estate planning, I think about me dying, leaving everything to my wife, or my wife dying, she leaves everything to me. These sorts of assets need to be handled much more carefully. I want them to go through a trust or through trust provisions. I don't want them going directly to my spouse or vice versa, because there's too much of loss that happens. You just burn money. There is a more um, sophisticated, thoughtful way to accomplish this and save your money instead of just giving it away. Now, let me go back to a couple of other things. We talked about the age of distribution, talked about entering college. What about those capital gains again? Most folks aren't aware of how a capital gain works, but here's in a nutshell. Let's say I bought a house 30 years ago, and now my $100,000 house is worth $300,000. It has gained $200,000 worth of value. So that $200,000 worth of value gets taxed at, depending upon my present income, either 15% or 20%. So the gain of 200,000 taxed at 20%, which would be the accurate rate at that level, means I'm going to pay $40,000 worth of taxes on that unless I get a capital gains exclusion. When do I get a capital gains exclusion? If I've lived in the house the past 2 of the 5 years, 3 under other conditions, but if it's my personal residence, that applies. Now, if I give that house to my children in advance, I'm no longer able to claim it as my residence. It's their property. They get no capital gain at all, and I've just given mine away. Conversely, if they inherit it from me after I've passed away, you automatically receive a step up in basis. Now, there's two things there. So the $40,000 worth of tax doesn't ever attach because I get my gain, my stepped up basis for the gains exclusion. But a capital gain exclusion only gives $250,000. So if I had a house that I bought at 100 and now is worth 400, I had a $300,000 gain. So I still have 50,000 above the $250,000 exemption. Excuse me. So you're telling me, Scott, you're automatically going to have to pay taxes on that additional 50,000? No. If it's inherited, you're going to get the stepped up basis and you would have no tax whatsoever. So that is one incentive built into our tax system to pass wealth down with an extra bonus on top of the 250. Now you can get the full 300 exempted out. Now, if the children keep the house for another few years and it goes up in value again, they're going to have gain on that. But there are so many advantages to keeping that property and letting the tax code work for you instead of against you. The homestead exemption also is another one. Maintaining control of the property as your residence, you're going to continue to get your property tax, but that's going to require Medicaid planning. If you use a trust, you can transfer the property into, especially if you're talking Medicaid, an irrevocable trust. And you are going to have to, in the irrevocable trust, you're going to have the ability to retain all your capital gain exclusion, but it's going to be excluded from Medicaid. We're subject to other little rules like the 5-year look back, things like that. But using the irrevocable trust allows you to keep all the tax savings and not have all of the fear about Medicaid forcing your sale of the home or having a state recovery upon that. So those are just a few of the ways that we are about estate planning, giving things in advance, not having the right provisions in your will, or avoiding trusts because they just seems too daunting for us. But you can see we've gone through 7 different categories, all kinds of things that can go wrong here. Disability, bankruptcy, remarriage, tax complications, all sorts of things that can go wrong. So with that said, I don't have a whole lot of questions in the chat so far. Thank you, Peter, for that reference on those. Resources are always good for us all. What questions do you have out there? I'll move to a slide so you can see the contact. What questions can I answer? I did forget to mention one thing. I said I would talk about opting against the will. Um, I've mentioned several times here about we're talking mainly about underage. It could come up also if you have a disabled child. But if I pass away, and let's say an ex-wife is going to care for my disabled son, she receives control of the finances. That's the context I used earlier. Well, let's say that's not the case. Just me and my wife, presently married, happily married. If I have all these provisions in my will that say various things are to happen, Kentucky law allows her to make a choice after I've passed away. Let me make the context a little bit clearer. The house that you see I'm sitting in right now, we own that, and we have a farmhouse south of town. This historic house, I would like for my daughters to keep on taking care of and giving it back to the public and holding tours. And I want my wife to be able to enjoy it if she survives me, but I want to give her the farm. That's our place. That's where we stay every night, except weekends. We stay here at this house. I give one to my wife, and I give the other to my children, my three daughters. Let's say my wife, after I passed away, said, I'd rather live in the Victorian on Main Street. She can, I will, and elect against it is the language. She can basically just throw it out. And instead of letting my daughters have this house, she, my wife, gets 50% of everything. Now, she cannot pick and choose, say, let me have that house instead of this one. But she gets 50% of everything across the board. Therefore, she could tie up the estate. My daughters probably would not be able to buy her out to get their share back of this house or anything like that. They're not her biological children. They were from my first marriage. She and I both had 20 years before we met one another. And although they get along well, it's never a good thing to be sort of handcuffed to a person that you don't have a blood relationship. It's hard enough with blood relationships a lot of times. So that could just be very complicated. This is one reason why you really want to think seriously about trust-based planning, because trusts cannot be opted out of, elected. They do have flexibility built into them, but not the way Kentucky law treats a last will and testament, where you can just blanketly throw it out. So I'm glad I remembered that. I was not sure. I should have written it down, but remembered saying now I'll go back to that. Look forward to seeing you next time. I hope you have a good week and take care.